case to be argued today is Souleatha, Calmese versus Tiara Harris. Only appellant, Ms. Harris, is arguing. You have 15 minutes to present your argument then. We have read your briefs, we're ready to begin. I would ask that you stay behind the podium, keep your voice up because we are being visually and audibly recorded.
Understood. Thank you.
You're welcome.
May it please the court, my name is Greg Sane and I'm counsel for appellant Tiara Harris. This case concerns the trial court's denial of Ms. Harris's motion for sealing or redacting the record of an eviction case filed against her and her family. Ms. Harris respectfully submits that under the circumstances of her case, it is contrary to public policy to force her and her family to suffer the negative consequences that can result from full access to the eviction record created against her. Ms. Harris filed her motion pursuant to Rule 45E of the Ohio Rules of Superintendents. This rule governs access to court records. For a tenant like Ms. Harris, the ability to apply Rule 45E to an eviction court filing record is particularly important. An eviction court filing record can have a significant and negative impact on tenants when it comes to seeking and securing future housing opportunities. This is particularly true for low-income families like Ms. Harris's family. Lower-income families are already challenged when it comes to securing housing opportunities. They should not have to suffer the additional burden of full public access to an eviction filing record wrongfully created when there exists Rule 45E circumstances for sealing or redacting the record. Rule 45E recognizes that in certain circumstances as identified in the rule, a higher interest will be served if full public access to a court record is restricted. In fact, in a proper case, the rule creates a mandatory duty for the court to restrict access to the record. In subsection 2 of Rule 45E, the rule specifically states that after consideration of the circumstances identified in the rule, a court shall restrict public access to information in the case document or, if necessary, the entire document if it finds by clear and convincing evidence that the presumption of allowing public access is outweighed by a higher interest. In this case, application of Rule 45E to restrict access to the record seemed particularly appropriate. The eviction court determined that the complaint was filed based on circumstances reflecting the unauthorized practice of law, and the case was dismissed.
And counsel, how was that, the unauthorized practice of law?
What happened here is, the complaint filed was not signed by the plaintiff. The complaint filed was signed by a person who, on the complaint, as indicated in the record, under the signature it says plaintiff/plaintiff's attorney. That's how the complaint is signed, plaintiff/plaintiff's attorney. The court's determination that the plaintiff failed to sign the complaint reflects the fact that the person who did sign the complaint was neither the plaintiff nor an attorney.
Well,
and so third parties cannot represent other third parties in court of law. Cannot represent a party, I'm sorry.
Doesn't the forcible entry and detainer statute allow for an agent to sign on behalf of someone?
This was not signed as an agent. This was signed as plaintiff or plaintiff's attorney.
Okay. And
this person was neither of those people.
So
the court determined that it was unauthorized practice of law, and that has not been challenged by any party here.
Well, and it was signed off on by a trial judge, correct?
And it was signed off by a trial judge, yes, Your Honor. When a court determines that a case has been commenced based on a complaint that was filed under circumstances reflecting the unauthorized practice of law, there is no case before the court to consider. The complaint filed is in effect a legal nullity. This court and other appellate courts, including those cited in Ms. Harris's brief, have drawn this conclusion, either dismissing the case or striking the pleading. When the pleading at issue is, as in this case, the initial court complaint, that is, the pleading that commences the court action, regardless whether the pleading is stricken or the case is dismissed, the legal effect is the same. There is no case before the court. The complaint is in effect a legal nullity. Ms. Harris respectfully submits that under the particular circumstances of her case, there is a strong public policy against allowing full and unfettered access to the court record created against her. Under subsection 2 of Rule 45E, public policy considerations are one of the key considerations when it comes to making a determination whether or not to restrict access to a court record. In this case, the public policy that prohibits the unauthorized practice of law is not advanced, and to the contrary, it is undermined when the movement's request to seal or redact the record is denied without explanation. Further, as an additional matter of public policy that applies to this case, significant harm could potentially occur to Ms. Harris and her family based on the mere presence of the wrongfully created court eviction filing record. As stated in her motion and affidavit, the ability to find and to secure housing opportunities can be seriously undermined based on an eviction filing record. Simply stated, and is self-evident, for tenants, there is nothing good that comes from an eviction filing that is in the public record. The interests of justice and public policy are not served under circumstances like those in this case. Some form of sealing or redaction is appropriate. It should be noted that Ms. Harris's motion was not a perfunctory one. It provided the court with a detailed explanation for why the record should be sealed or redacted as a matter of public policy and in order to protect Ms. Harris's privacy rights as a tenant.
Counsel, was the motion filed after the judge dismissed the case?
Yes, absolutely, yes. It was filed a little bit after 30 days after the court's judgment. The motion and the affidavit, the affidavit that accompanied the motion and the underlying case record as contained in the court file clearly demonstrated a basis for a Rule 45E higher interest to be served by sealing or redacting the record. In the event the court was not inclined to grant the motion as filed, Ms. Harris asked the judge, a judge who did not participate in the original eviction case, for the opportunity for a hearing on the motion. Without explanation, without granting the request for hearing, the court summarily denied the motion. As a result, to this day, Ms. Harris does not know if there is any future event, such as the passage of time, that the court would deem sufficient for the court to approve her motion. If, for example, Ms. Harris filed a second motion 6 months or a year from the date of the initial eviction judgment, as opposed to having filed it 30 days after the initial judgment, would the court now approve her motion? Although Ms. Harris's motion was not prematurely filed in light of the fact the court record was created in violation of the prohibition against filing court complaints based on circumstances reflecting the unauthorized practice of law, the lack of any guidance from the trial court when it denied her motion without explanation means that Ms. Harris must now guess whether the court considers a future event, such as the passage of time, is enough to cure her situation for purposes of sealing or redacting the record wrongfully created against her. With respect to Ms. Harris's hearing request, Rule 45E, subsection 1, grants the court discretion whether or not to hold a hearing on the motion. However, Ms. Harris respectfully submits that in light of the court's mandatory duty under subsection 2 to limit access to a court record in appropriate circumstances, a motion for record sealing that presents operative facts demonstrating evidence of grounds for sealing or redacting the record should require a hearing if the court is not going to grant the motion as filed. Ms. Harris believes that, as discussed in her brief, a consideration of the procedure under Civil Rule 60B governing motions to vacate would seem to be useful. Under the rule, when a motion filed presents operative facts demonstrating a right to relief, if the court is not going to grant the motion as filed, the motion to vacate is filed, the court should properly grant the movement's request for the opportunity for a hearing so the merits of the motion can be addressed. The Rule 45E hearing gives the movement an opportunity to present evidence and argument in support of the motion. The hearing also better enables the court to make a proper Rule 45E subsection 2 determination whether or not it has a duty to seal or redact the record based on a higher interest to be served. The hearing creates, as in the case of a criminal record sealing, the opportunity for the court to engage in any additional information gathering or fact-finding that the court deems necessary. The hearing also creates the opportunity to discuss the extent of any remedy for restricting access to the record. For example, should all the record be redacted or sealed or a portion? In light of the Rule 45E, subsection 2, mandatory duty for a court to limit access to a court record when a higher interest will be served, the court should at a minimum grant the request for a hearing when it has before it not only a motion and an affidavit like that of Ms. Harris, that reasonably presents operative facts demonstrating evidence of a basis for sealing or redacting the record, but also a court case record that fully supports the motion. Denying the motion without explanation is contrary to the letter, the intent, and the spirit of Rule 45E, a rule that appears designed to have a certain remedial and curative effect. Ms. Harris respectfully submits the summary manner in which the court treated her motion did not properly reflect the substantive nature of the motion filed and the significant, separate, independent, and original nature of Rule 45E motion proceedings addressing access to a court record. The summary manner in which the court treated Ms. Harris's motion also did not reflect the policy of the courts to hear cases on their merits. To deny the motion and to deny her request for a hearing and to provide no guidance for why the motion was denied is highly unreasonable, arbitrary, and capricious. As previously discussed, for a tenant like Ms. Harris, the ability to apply Rule 45E to an eviction case filing record is particularly important, since as stated in her motion and her brief, an eviction filing record can have a significant and negative impact on tenants when it comes to seeking and securing housing. The sealing or redaction of the record is in an appropriate case gives the family a new lease on life, if you will, a second chance. It is worth noting that Ohio has created a number of second chance opportunities. Criminal record sealing has been expanded. The Ohio Ban the Box law banning criminal record questions on job applications for public employment, which creates the opportunity for a job applicant with a blemished record to have a conversation with a prospective landlord. All of these efforts recognize the need for a second chance in order to help create a path to self-sufficiency and housing opportunity.
Counsel, what
Yes.
you just said being a true statement, isn't it the legislature's job to put that second chance into place? And
Well, I
has
think
it?
the Rule 45E, I think, as adopted by the Ohio Supreme Court, can have the same effect. You know, that rule is merely addressing when and under what circumstances public access to a court record will be permitted.
Well, then arguably criminal defendants could use 45E
Yes,
also.
I think that's correct, Your Honor.
You think that's the intent of 45E?
I think it can be under appropriate circumstances. I think it just kind of depends. I mean, there may be a situation where there would be some need that maybe wouldn't be covered perhaps even by the statute. I'm not sure. I'm not a criminal record sealing person. I don't do criminal cases, so I'm not sure on this, but there may be some circumstances where a court might determine it's appropriate for that reason. You know, the difference is when you, or at least one of the big differences is under Rule 45E, you can seal access to the record, but for example, in this case, Ms. Harris, if a landlord asked her whether she had been previously subject to an eviction, she would have to say yes. So it doesn't have that same effect that a criminal record sealing has, but it certainly has a benefit to a tenant because it allows them to potentially have a conversation with the landlord. In fact, actually, I've got a bit of a paragraph that kind of explains a little bit about this. It says...
Can I ask you a question before you go into that?
Yes, yes.
Well, you have 3 minutes. I'm sorry for interrupting you, but
It's okay. I didn't start till it was 3 minutes in.
Oh,
So.
anyway, I apologize. Well, the question I have is, some courts have local rules in regard to this.
Yes.
How do they do that? I mean, is that on the basis of 45 or what? 45E?
I think potentially, yes, Your Honor.
Okay.
You know, I haven't...
Cleveland Municipal Court, I think, has it.
Yes, and I think even Columbus has adopted some sort of restriction on public access. I know Virginia was considering that. And so I don't know all the courts. You know, I don't know which courts exactly are doing what. I do know that there's, because of the affordable housing crisis that goes on, you know, the Ohio Housing Finance Agency found that there's an affordable housing crisis in the state of Ohio. And that's a separate state agency. And this is an attempt, I think, or one attempt to just try to put people in a better position to be able to secure housing. I think that's what this is designed to do. And I think that in Rule 45E in an eviction context can have that same effect. You know, with the advent of online, immediate, and ready public access to court records, the adverse impact that comes from the mere filing of an eviction has been enhanced. The ready access to the fact of the filing is now enough to prevent a tenant like Ms. Harris from receiving the benefit of either the landlord's return call or the opportunity for a conversation with the landlord. The landlord's online court record search is enough to both begin and end the opportunity for any conversation. Sealing or redacting the record at least creates the opportunity for a tenant to have a conversation with the landlord. Ms. Harris and her family deserve the second chance opportunity that a Rule 45E motion can provide. As stated in her motion, compared to a criminal record sealing situation, she's being treated more harshly than a 5-time felon, when the eviction record created against her should, as a legal nullity, not even be there. There's something not right about the way this was handled by the court. As previously stated, the stigma created by the filing of an eviction is an area of special need for tenants, particularly tenants and their families like Ms. Harris, who already have limited housing options as a result of limited income. Ms. Harris cannot predict what a new prospective landlord will do when considering her as a tenant. However, it can be stated with 100% certainty that the eviction record wrongfully created against her can now only potentially harm her and her family going forward. Ms. Harris respectfully requests that Rule 45E be applied to minimize the additional burden that this wrongfully filed complaint will have, or at least be given the opportunity for a hearing on her motion. Ms. Harris requests this court determine that it is appropriate to seal or redact the eviction record, in this case, specifying the manner in which it should be sealed or redacted, or remanding the matter back to the trial court for that court to determine the manner in which the record should be sealed or redacted. In the alternative, Ms. Harris requests that this court remand the matter back to the trial court for hearing on whether the record should be sealed or redacted and the manner in which it should be sealed or redacted. Thank you.
All right. Thank you very much for your argument. We will take the matter under advisement, issue a written decision in due course. It will be mailed to you, both sides, as well as posted on our website and on the Supreme Court's website.
Thank you.
Thank you. Have a good day.
Thank you.